Welcome, everybody. Today we're here with Marshall Tanick. He's a notable attorney with a niche in media law. Marshall, if we could begin by having you tell us about your background, your academic background, and if you want, about your firm, that'd be great.
Thank you very much. A pleasure to be here with you, Jacob, and have this opportunity to talk to some of your many podcast viewers and listeners. Uh, Real brief background. I was born and raised in Minneapolis. I went to North High School, graduated from the University of Minnesota School of Journalism. I intended to become a journalist and still do a lot of journalistic work. I went to law school at Stanford University. I've been practicing law for a long time in different formats. I worked for a federal judge for a couple of years before starting my law practice. Much of my work is media related, involving privacy and defamation and constitutional law. It's not all of my work. It's not even the majority of my work, but certainly a significant portion of my work consists of media related matters, particularly defamation and privacy. And much of that is online work. Hardly any of the defamation work that I do these days relates to the conventional defamation like newspapers and magazines and television and radio. Some of it does, but so much is on the internet highway these days that almost all of my defamation work pertains to online defamation.
I'm not surprised to hear that with the advent of the internet and social media. I'd love to dive into your motivations for becoming an attorney. Is it something you've always been passionate about? I noticed you just kind of said you intended to be a journalist, so it's kind of a bit different.
Well, it is. No, I didn't I wasn't passionate about it, and I wasn't even intending to become an attorney. I wanted to be a journalist, and I did work as a journalist in the early part of my career, and still do a lot of journalism. I edit law magazines, and I write 5 monthly columns for different law and business publications. For instance, this morning, Tuesday, September 16th, I had a piece written in a Min Post, the online newspaper, dealing with gun violence. Yesterday, I had an article in the Minnesota Lawyer magazine about some political issues. This weekend, I have an article appearing in the Duluth News Tribune about Governor Walz and his election campaign. So I do a lot of different writing for a lot of publications. Some of it is for compensation, but it's very slight, and I donate that compensation to charitable organizations because it's not my main preoccupation. But back to your question, I did intend to become a journalist, but when I was an undergraduate, my journalism professor saw that I had an interest in legal issues, and he suggested and kind of steered me in the direction of law. When I initially became when I initially went to law school, my intention back then was to have a law degree and be a journalist covering the courts, which was fairly
Mm.
unusual back then. If you go back well before your time, Jacob, 40 years or so ago, it was extremely rare for people in the journalism field to have law degrees. Now, many of them do. Many of the broadcasters do. Many of the people you see on television and many of the podcasters do. But back then, it was pretty unusual. So I sought to, but I want to have a law degree and become a journalist reporter, a law reporter. And I was offered a job by the Washington Post when I got out of law school to be a journalist with my law degree. And but the job they initially offered me as a beginning reporter was a cub reporter covering the suburban Washington, D.C. beat, which is where a lot of reporters start out covering school board and covering police beat and local politics and things like that, which are important, but it's a starting spot for many journalists. But I didn't want that. I thought I should be starting right off at the Supreme Court level. But so I turned down the job and decided to stay in a law career primarily. The person who took the job that I turned down is a fellow named Bob Woodward, who was one of the Woodward and Bernstein of the Watergate fame.
Oh, wow.
It was portrayed in the movie, in the Academy Award-winning movie All the President's Men by Robert Redford. The late Robert Redford played Bob Woodward in the Academy Award-winning movie All the President's Men. That was a story of the Washington Post breaking the Watergate story way back when. That was the job I was supposed to have, but I turned it down. I wouldn't have looked as well as Robert Redford did on the screen anyway.
Oh, wow. So, what advice would you give to anyone wanting to follow in your footsteps? Obviously, going to college is a given, but after that, how would one approach picking a subset of law to practice, and how would they go about finding like a firm to work for?
Well, and not all lawyers work for firms. There's a lot of different opportunities for lawyers these days, more so than in the past. But if someone's inclined to go to law school, um, they don't necessarily have to decide that they're going to be a practicing courtroom lawyer like I am. There's a lot of different jobs for lawyers these days, particularly in technology and the internet and so on and so forth. But I think some basics are get a good liberal education. I don't necessarily mean liberal political education, but get a broad education as an undergraduate and do a lot of reading. Reading is extremely important if you like to read.
Hmm.
Even if you don't like to read, you should read anyway. Reading is important because one thing reading does for me and I think other journalists will tell you this is that reading makes you a better writer because you can see how other people use words and compose words and what words work and don't. So those are two pieces of advice I give people generally. Read a lot if you can and absorb the reading because it'll help your writing. In terms of kind of picking a niche, well, you don't have to necessarily pick a niche, but it's important to have a pretty broad education. As I said, history is important, political science is important, those kind of features. But of course, people branch off into particular areas. There's a lot, as a journalist, you may say, I want to be a science reporter or I want to write about technology. So obviously, you tend to specialize in those areas. But the points I just made are just kind of general across the board points that are helpful, I think, and valuable for any person wanting to become a journalist or a lawyer or both.
Okay, so let's go to the matter at hand. Earlier this week, the Minnesota Court of Appeals ruled that a woman's Google and Yelp review was not protected speech and that she could be sued for defamation. And a little background for those that are unaware of this, the woman had some dental work done. She was, for lack of better words, left unsatisfied, went to another dentist who informed her that the work needed to be redone. She then reconnected with the original dentist to work on a solution in which the original dentist offered to remedy the situation by refunding her insurance cost as long as she released all claims of liability towards them. She responded by requesting $2,000 to be paid to her personally on top of the $1,278 for insurance. And then she said if she didn't get paid, she'd take action, which included making public reviews. After making various reviews on various platforms talking about her experiences, the dentist requested that she remove them. She then responded by editing the reviews and then included that the dentist, in her opinion, threatened her with legal actions. The dentist then sued her for defamation. The woman motioned for the suit to be dismissed under the UPEPA, citing that this was, in her opinion, free speech and of the public's concern. The judge then denied that motion because platforms like Yelp and Google essentially don't allow for a public discourse where the problems could be freely discussed. Later on, the appellate court went on to add that her sharing of personal experiences and lack of engagement with the broader public were the main factors in their decision. The appellate court said that reviews can be considered free speech, but her reviews failed to meet the threshold of public concern, therefore, the UPEPA didn't apply. So there's a lot to unpack there. To begin, could you maybe explain what the UPEPA is for our viewers?
Sure, you gave a very good summary of the case, Jacob, from about 50,000 feet, and it was very accurate. The UPEPA is a whole new ball game. There's 18 states at last count that have this law. Minnesota is one of them. Minnesota adopted its law last year. It's a movement that is largely created or promoted by the news industry, the media industry. What it does is for those states that have this law, the U in the UPAEA is a uniform law. So they prepare this law and they present it to legislatures. And as I said, 18 states have adopted the law and almost always in the same, in the same format with slight tinkering from state to state. But basically what it provides for is if someone brings a defamation case, the defendant, the person against whom the lawsuit is brought, can ask the court to dismiss the case at a very early stage, right at the beginning, if the person can show, if the defendant can show that this is a matter of significant public concern. That's the key phrase in the phrase you used. And if the defendant can show that this subject is a matter of significant public concern, and it can ask the court to dismiss the case in order to protect the freedom of expression and the free flow of information. That's the theory behind it. It allows it allows the defendant to bring a motion, as you point out, to get the case thrown out of court right at the outset before the plaintiff can engage in any kind of discovery or investigation or subpoena records or do anything to pursue the case. So it's a significant way that a defendant can try to get a knockout punch in the first round of the fight. If the court denies the motion, as it did in this dentist case, then the defendant can appeal that immediately to the Court of Appeals. In almost all situations, and this is kind of inside baseball information, but in most cases, if a motion is denied, a party can't appeal that until the whole case is over a year or two later. But this law lets a defendant immediately appeal a case to the Court of Appeals without having to subject itself to discovery, depositions, subpoenas, without having to give any information to the other side, which is usually necessary for the plaintiff to pursue a case. So the defendant gets a chance to throw the case out right away before the plaintiff can even get started. If the motion fails, as this one did, the defendant can take a motion to take an appeal to the appellate court. That takes about 9 months. So a defendant it costs usually anywhere from $15,000 to $25,000 for the plaintiff. So a
Wow.
defendant can move to knock out a case. It can then move, if it loses, it can take the case to the appellate court. So that's going to take about 9 months to a year. Meanwhile, the plaintiff has not been able to start the case. And meanwhile, the plaintiff is going to end up spending $25,000 to $50,000 before the case even starts. And even if the defendant loses at that stage, as happened in this case, as can happen in a case, then it just starts all over again. So what it does, Jacob and listeners, is it really puts a great impediment on pursuing defamation cases. And I tell my clients this: if you're going to start a defamation case, there's a significant likelihood that the other side is going to try to knock you out in the first round. And people say, well, that's okay, I can withstand that. And maybe you can, maybe you can't, because if the defendant can show it's a matter of public concern, and many of them are, the defendant might knock you out before you even get started. But even if the defendant loses, they can take this through the appellate court and take another year of your time and make you spend $25,000 or $50,000 just to start your case. That's pretty daunting. There's another feature too. If the defendant wins on these motions, the plaintiff, the claimant, has to pay the defendant's attorney's fees, but not vice versa. I'll repeat that. If the defendant wins to knock the case out, the plaintiff, the claimant, has to pay the defendant's attorney's fees, which may be $25,000 to $50,000 or more. However, if the defendant loses, the defendant doesn't have to pay the plaintiff's legal fees. So you can see how the field is tilted here
Hmm.
greatly in favor of people who are being sued for defamation. Maybe it ought to be that way, maybe not, but that certainly is the import of the law. It makes it much harder for people to bring these cases, and lawyers like me advising clients have to tell them this. Hey, you might have to wait a year to get to court. You might not even win in court. And if you don't win in court, you have to pay the other side's legal fees. And if you do win in court, they don't have to pay your legal fees. Lots of plaintiffs are going to pause and say, well, you know what? Maybe I'm not going to pursue a case like this. So the UPEPA tilts the field in a major way in favor of defendants, mainly the media, but it's not always the media. In this case, it was the patient of the dentist. But the upshot is it makes it much, much harder to pursue and to win defamation cases, and it discourages people and lawyers to pursue defamation cases. And laws like this can drive people like me out of business.
Oh my gosh. I
Not
never
quite.
even realized it was so.
Yeah, it's quite daunting if you get down to the basics. And people who do this kind of work, and there's not a lot of us, realize how daunting it is. It is extremely daunting, and I'm not overemphasizing it. And this case typifies that.
So would I be right in assuming that you've probably seen like a mass decrease in people seeing defamation
Well,
cases and
I
pursuing
can't
them?
say that. I can't say that because no one keeps statistics on defamation cases, and this law has only been in effect in Minnesota for 1 year, and in other states for only a couple of years. So
Okay.
I can't say there's been a mass declination of defamation cases, but I can tell you that lawyers who do defamation cases, like me, are telling clients what I just said, and the impact is undoubtedly in my cases. Yeah, people are talked out of and discouraged from pursuing these cases because the field has been so tilted against them. And when they hear me say this, um, they tend to shy away. Now I represent plaintiffs too, pursuing these cases, but I also represent defendants. For defendants, this is the law is very helpful. For people pursuing cases, it's very unhelpful. And I'm sure there is a decline in cases. There's a decline in the cases I've taken. I can't statistically say what it is, but I'm sure it's going to be significant, especially as more people know about this law. It's still a new law. As I said, it's only been on the books for a year. This is only the second Minnesota case that's involved that law.
Oh wow. Now I'm not sure if you can really delve into more of your thoughts on the matter. Do you think there's a place for this law, or do you think maybe we went a little overboard?
Well, this law replaces what used to be called the SLAPP laws, which I was involved in and was involved in a case that threw out the SLAPP law as unconstitutional. The SLAPP law was called SLAPP, S-L-A-P-P, Strategic Litigation Against Public Participation. Minnesota and many other states, oops, I just lost you there. Um, I'm off camera now.
Oh, I still see you.
Okay, I just pushed the wrong button. I'm sorry, I can't see you, but can you still see me?
Yep.
Okay. Uh, what there I am. Strategic litigation against public participation law, which Minnesota and many states had, was a version of this law, but it wasn't quite as draconian. What it did do is allow people to pursue when people were sued for defamation, it allowed them to make a motion to have the court dismiss the case, and if it involved a significant matter of public concern, but the courts ruled that it was unconstitutional because it deprived people of a jury trial. The SLAPP law said that only juries can't decide these cases. So I had a case in which the Minnesota court threw out the SLAPP law and said it was unconstitutional because it deprived people of a jury trial. So we won that case. But what happened is they went back and changed the SLAPP law and made it much more difficult for plaintiffs to pursue cases. So this is a this is a SLAPP law on steroids.
That's crazy to think about, actually. So, I mean, I guess I can understand where the courts are coming from with the Yelp and Google not being a true public form of discussion. It's pretty one-sided. You leave a review, and whoever you left a review against might be able to comment, but the public really can't. So, in my own experience, I've also had like a dentist that had controversy surrounding them. They lost their license, blah, blah, blah. The local citizens made a Facebook group to kind of band together. And I could see that being a bit different because, a Facebook group allows public participation from everyone, pretty open, pretty free. So I can empathize with this woman's, issue, I guess. But I guess I'm surprised that it's kind of it's leaving a bad taste in my mouth because are people now supposed to be afraid of leaving reviews? Like, how does this change the nature of the consumer if you actually do have a bad experience? What are you supposed to
Oh, it's a
do?
big change, yeah. And I have many cases, including a couple of dentist cases, just like this. Um, and I've been on both sides of these cases as a lawyer, so I'm not saying one case side is right or wrong, but
Hmm.
consumer cases make up a large number of these, or consumer grievances make up a large part of this internet highway. The most common defamation cases online are familial matters, family relationship, intimate relationships. A lot of claims, mainly by women, not always, but mainly by
Hmm.
women against men claiming that they were sexually assaulted or sexually abused, or in divorce cases where both parties go online and make statements about the others to try to affect the outcome of a divorce or child custody or parenting issues.
Oh,
Uh,
wow.
but the consumer cases are a significant portion of the on the highway too, and they're complaints made by customers against oftentimes professionals, doctors, lawyers, uh, dentists, accountants, and the like. Dentists are very susceptible to these claims for lots of maybe obvious reasons because people don't always get what they want and they come away from their dental appointment dissatisfied. And I have a very good dentist, and I just had a I just had a dental procedure done yesterday. It worked out very well. I'm not going to go online about that, other than say but
Yeah.
one can appreciate how sensitive, literally and figuratively, these matters are. If a patient feels that their dental work didn't turn out the way they expected or the way they were told, it's easy to go online because there's no editors, there's no filters, and people can say what they want. These cases, and oftentimes then the vendors, the people against whom the statements are made, will strike back with what's called a cease and desist letter. That's usually the starting point. I'm sure that happened here where the dentist will write a cease and desist letter, as I did a couple of weeks ago for one of my dental clients. They write a cease and desist letter to the claimant saying, "Hey, you've said some negative things that are false. Please take it off, or we're going to sue you," and so on and so forth. And most of the time, those cease and desist letters work. I've in cases involving businesses and customers, about 80% of the time that I write a cease and desist letter, the customer walks away and says, "Okay." My letters aren't very harsh. I just say, "Please do this, and we don't want to involve you in litigation." And most of the time, the customers will go away, but sometimes they don't. Um, and this is case is unusual, as you pointed out, Jacob, because in this case, the patient uh, said that she would take it off the internet, but wanted to, I think it was $2,000, which sounds a little bit like it could be an extortion or coercion type.
That's what I was gonna ask too. That sounds
It
like
could be.
coercion to me.
Well, it could be, but in many legal disputes, someone will say, "I'll stop doing this if you'll pay me money," and that's part of the legal process that we have in our country. So I wouldn't call this extortion or coercion, but it certainly has a ring to it that some people would feel is coercive. And that's unusual, but I've seen that happen where someone says, "I have a right of freedom of speech and I can say what I want. However, if you want me to remove this, I will do it if you pay me." That's not real common, but it does happen. And that was this case, which I think left a bad taste in the mouth of the judges too. I wouldn't encourage people to do that. In fact, I discourage them from doing that. But nevertheless, that was an underlying issue in this case that made it a little bit not unique, but rare.
So if a consumer does have a bad experience, then how can they go about raising awareness for the community if they genuinely do feel like there's an
Yeah,
issue?
and that's a fair question. I mean, it's because these laws can be so harsh to the consumers, it oftentimes will deter and suppress consumers from being able to communicate to other people what happened to them. Apart from the cathartic value that it has, it also is a way of alerting people to maybe not just a dentist, maybe a product that has some bad after effects. Or I had a case, for instance, it wasn't quite like this, but a case where my client had bought this dog toy, and the dog had swallowed the toy and
Oh
got
no.
very sick and needed $23,000 of a surgery to repair the intestinal tear. And my client wanted to communicate to other people about this dangerous toy. She tried to get it off the market and went through the FTC, and that didn't work at all. So she went online, and fortunately, it did have some effect. And we dealt with the company. She got a settlement from the company, and they paid her because of the injury to her dog. But it was a and then she did agree to take it off the internet. But she did have the ability to communicate to other people about this dangerous device, and the company did back off, and they took the device off the market. So that one worked, but not all of them do work. But in terms of answering your question, um, there's several options for what a consumer can do. One option, of course, is to do nothing. That's always an option. Another
Hmm.
option is to talk to other people, but don't leave a paper trail on the internet about it. But the problem with that is it's very limited. You can't talk to that many people if you want to get out to the world at large. Third option is to complain to the Better Business Bureau. That sometimes is effective, sometimes ineffectual, but it's there. And the Better Business Bureau is an organization that will look into these complaints, and sometimes it can be effective. A fourth option, or another option rather, is to complain to the licensing bureau. That can get a little bit draconian though, and oftentimes quite cumbersome. And I discourage my clients from going to complain to boards, licensing boards in these situations, because it just ties them up and entangles them in some very unpleasant situations. But that's a possibility. In really egregious cases, you can complain to the licensing board, that the licensing person, if they're licensed lawyer, doctor, plumber, attorney, accountant, people who have
Hmm.
licenses, they have boards that regulate this, and those boards will look into these complaints sometimes. But those boards oftentimes get a lot of, I won't say frivolous, but at least rather small complaints, and they don't like to deal with those small complaints unless something very serious. And another option, of course, is to go on the internet. And I've had people come to me as a lawyer to ask me before they go on the internet, "Can I say this? Will you edit this for me? Is this a safe harbor for me?" And there are certain things that you can say and ways you can couch your language in such a way that it might minimize a defamation lawsuit. It won't prevent it, but there's certain ways that you can say, "Well, this is my opinion and this was my experience, but maybe other people had different experience." You can water it down quite a bit. The problem
Hmm.
watering it down quite a bit as it gets so diluted, you'd lose your point.
Yeah,
So
that's a good point.
if you really want to make your point, sometimes you have to do it in a rather strident way. And if you're too mealy-mouthed about it, say, "Well, this happened to me, but I'm not sure it might happen. It would happen to someone else. So don't take my word for it, whether you're wasting your time in the first place." So it's a hazard and it's a risk. And incidentally, in some cases, insurance covers people who make these statements. If you make these statements from your home computer or laptop, or if it's your own laptop, your homeowner's insurance might cover you. So if someone sues you for one of these statements, you can turn it into your insurance company. You might get covered by your insurance. However, that's the good news. The bad news is your insurance might cancel you too. So there's a lot of risk. And I told people that if you want to go on the internet and make these kind of statements, you ought to be careful what you say, but you also ought to be aware that it's a risk. Now we take risks all the time. Every time we turn on our car ignition, we're taking a risk. But you have to weigh the risk. Is it worth it? Is what I'm saying important enough to me to take the risk that I might be sued for it? And suits are very rare. Although, Jacob, I do a lot of this kind of work and I've been doing it for maybe 25 years on the internet, a lot since the internet's been a busy highway. I've only had 3 or 4 cases that have actually gone to court like this. Most of the
Oh,
time,
wow.
most of the time the parties can work it out with letters and negotiation, and sometimes there's some exchange of money. But there's ways of solving these cases without going to court. Because if you go to court, you're spending a lot of both sides are spending a lot of money and spending a lot of time, and it becomes public too. So in this case, the dentist now is a public information about this dentist, which probably doesn't redound much to the dentist's benefit or to the other person's benefit. So going to court sounds good sometimes and sounds heroic, but there's a lot of downsides to going to court, including the expense and the adverse public impact that it has on everybody involved in the case. So these cases are rare, but they are occurring with greater frequency. By the same token, as I said, I've had a few of these cases go to court. Most of them get resolved outside of court.
Wow. Yeah, there's a lot to unpack there. I mean, even in my instances too, I've chatted with I think it's the Minnesota Board of Dentistry, the lady who was the director of that, and she was more than happy to help. But she also basically said that they're pretty toothless and said that it's up to the individual to actually sue if they feel wronged. So it's
Yeah,
interesting
that's
to hear you
correct.
say
Yeah,
that.
unless it's a very whether it's a dentist or a doctor or some other professional, unless it's a massive failure of competence, the board will take in the case. The problem with that is if people do that, I tell people is if you go to these boards and you complain, you're probably not going to get a favorable ruling. And then if you decide to do something else, like go online, you've hurt yourself because you already have a bad ruling from a board. So I urge people to, the boards are the last resort, not the first resort. If you decide to do nothing else, that's the Hail Mary pass.
Yeah, I've learned that the hard way too. I've had a bad ruling from a board and I got it used against me and it totally backfired, but I didn't know any better. Now I do.
I can't think of more than 1 or 2 situations I've been involved in where I've encouraged a person to go to any board on these matters unless it's hugely there's a huge discrepancy from competent practice.
Wow. Wow, this has been really informative. That pretty much sums up my questions. Do you have anything else you want to add?
No, I think you've asked some good questions. I think this is a hot button area. Everybody's on the internet these days. Um, and this case, incidentally, it's called this decision by the Minnesota Court of Appeals the other day is called a published decision. What that most of the decisions by the appellate court in Minnesota are not published. They're called unpublished. They're available to the public, but they're not precedential for other cases. They're called
Hmm.
unpublished. It means here's our decision, do what you want with it. But in some cases at the court that the judges feel is important, they call it published decisions. And that decision then becomes available to all the lawyers and everybody else. And then it becomes cited as precedent. And as you noted, because you jumped on this right away, this is a big case. It's going to be a lot of precedent, as we lawyers say, for other cases. This is going to have a lot of effect on other cases. Oftentimes, I mean, the upshot here is that because it was Yelp, and it wasn't a dialogue because it was called a personal grievance. There was no great public interest here. That's what the court said. This matter was not of great public interest. It was important to the people, but it didn't raise some social or political or ideological issues. Had the person been complaining about something else, like maybe they'd been assaulted or there had been some fraudulent billing to an insurance company, something that affects the public, the court might have viewed this differently, but basically the court said this is just a personal grievance between a customer, a patient, and a dentist. And while we don't know who's right and wrong, it doesn't rise to the level of significant public interest that warrants a defamation lawsuit.
Oh, one final thing. In that draft you sent me of a cease and desist,
Yeah.
I noticed here it mentioned the patient satisfaction agreement. I can't speak. Is that a tool that practices like dentists and maybe retail
Uh,
stores and others can use to maybe, what's the
yes.
word, control negative reviews?
It is. And what I sent, I have a particular case where the dentist uses this with patients. It's a good idea because you get some input from patients. If things went wrong, if the receptionist wasn't nice, if the waiting area was not well attended to, if,
Hmm.
it gives the professional, the dentist or other professionals some input on ways to improve. But firstly, secondly, if the person doesn't register any complaints, later on goes on the internet and starts making complaints, the person can point it out and say, hey, wait a minute, you didn't make any complaints. We gave you a chance to do so. So it's a good device for businesses, especially small businesses, to have some kind of patient satisfaction device that allows the patient to express their opinions or their evaluation of the work. Our law firm has done that in the past. Sometimes it becomes a little bit laborious, it's time consuming, and sometimes people don't want to do it. But it's not a bad device for small businesses. I wouldn't say to do it all the time, but in
Hmm.
dentistry in particular, it can be a useful device because there is so much tendency, or at least there's so much opportunity for misunderstandings about the nature of the work being done and the quality, not the, and the result of the work, which sometimes patients assume is going to turn out better than it is, and there's often variables that the dentist can't control.
Understood. Well, that wraps it up. Thank you so much for taking time out of your day to help us discuss this matter. It's going to be interesting to see what evolves from all of this and how everyone moves forward with UPEPA and how it's going to impact everyone's lives and businesses. If you'd like, you can shout out your law firm. If you want, I can, direct people to you. Maybe people will hire you to review their Facebook post. Who knows?
I do some of that, and also businesses can, contact me to talk about having some kind of customer satisfaction survey to be done. But the name of our law firm is Meyer News Tanick. We have three offices. Our main office is downtown Minneapolis, although as I tell people, hardly anyone ever comes there because the parking is so difficult. But we have an office in St. Louis Park. We have an office in St. Paul, and we do a lot of general litigation and legal work. And as my field generally is employment law, constitutional law, and defamation and privacy law. And I'm happy to talk to people about their concerns and needs. And I appreciate this opportunity, Jacob, you've given me to talk about a very interesting and important issue that's evolving. We're just seeing the evolution of this because the law is so new, and we're going to see how it affects people in a significant way in the work I do. And consumers and professionals dealing with significant problem areas.
Awesome. Well, thank you so much again.
Thank you.